students, this is Dr. Bansode, and today we'll discuss about Article 14 of the Constitution. Now in Indian Constitution, we understand that in Part 3 of the Indian Constitution, there are various fundamental rights provided. These fundamental rights, they are nothing but the charter for each and every individual within the territory of India. Now, these fundamental rights, they are basic, inalienable, non-transferable rights. They are the possessions of all the individuals. In the very first page of the Indian Constitution, and that is in the preamble, we proclaim that we will maintain equality of status and of opportunity for each and every individual within the territory of India. Before the adoption of the Constitution, in 1948, Universal Declaration of Human Rights also consists of with the provision of right to equality. Not only UDHR, when we see the contents of Magna Carta, Bill of Rights, or the very old Constitution of America, in all these international documents, we do found the concept of equality. Equality all accepted as a very natural right, the right which is recognized by one by birth itself. And so, when we see our Constitution, and that is Part 3 of our Constitution, we also recognize Article 14, that is right to equality, as one of the very important fundamental right of each and every individual. Now in this, when we read Article 14 of the Constitution, what it says? It says, state shall not deny any person equality before law and equal protection of law. So right to equality, as I said, is a natural right, basic right, inalienable right. It is a possession of an individual. By birth, that right is recognized with the person. In Article 14, it is a responsibility of state that state shall not deny any person equality before law and the equal protection of law. So state must assure that there will be no discrimination before the law, and there will be positively everybody will be protected by that particular law. And so, as per Article 14, there are two concepts. One, that is equality before law. Another, that is equal protection of law. Now this equality before law we understood from the English common law system. It means that There should be absence of any special privilege to any person. तो किसी भी इंडिविजुअल को कोई स्पेशल प्रिविलेज नहीं होना चाहिए. And all should be subjected to one particular ordinary law. और सारे लोग एक ही लॉ को answerable हैं. And that is the ordinary law. So it means that law must be generally applicable to all. And so like should be treated alike. So equality before law is nothing but absence of discrimination. There shall not be any discrimination before any particular law on any extraneous grounds. तो दूसरा concept है, that is equal protection of law. This concept originates in American Constitution. What it means? It again casts an obligation on the state that state should see that they are making such particular law in which everyone protected equally. And so in that sense, this is a positive concept. This is enabling concept. And through this concept, state can see that how everyone in the legal system will be equally protected. So equality before law is a negative concept, that there shall not be discrimination before the law. And equal protection of law is a positive concept, that the state shall see that everybody is equally protected before that particular law. So Article 14, which provides for equality before law and equal protection of law, that is, in a positive manner, the protection of law should be provided equally by the state. But here we need to understand that each and every individual is situated in different circumstances, and law must take into account even the circumstances of that individual. And that's what the like should be treated alike, not unlike should be treated alike. हर एक इंसान की सिचुएशन, सर्कमस्टेंसेस, उसको ध्यान में रख के इक्वालिटी जो है वो वहाँ पे एक्सरसाइज करनी पड़ेगी. So though Article 14 provides equality before law, it means that everybody is equal before the law. But there are certain persons, like President. He is a privileged person. And so Constitution recognizes some privileges, immunities to that constitutional head. So on that ground, we cannot justify the right to equality, that even president should be treated like a common man, because the circumstances criteria which requires that somewhat different treatment as per the law must be provided to that authority. And by doing so, we are not violating the very content of right to equality that we need to understand. And for this reason, Article 14 evolved with the doctrine of reasonable classification. Now, what is reasonable classification? Reasonable classification means make a class of all equal persons and treat them equally in that class. So क्लासिफिकेशन होना चाहिए, लेकिन वो रीजनेबल बेसिस पे होना चाहिए. So you have to make a class of all persons who are situated in equal circumstances, and in that class you have to treat each and every person equally. That is called a reasonable classification. By doing so, we are actually attaining the goal of equality in the system. And so, Article 14 prohibits class legislation, but Article 14 provides a reasonable classification. What is the test of reasonable classification? That the classification should be made on intelligible differentia. So जो क्लास आप बनाते हैं and the object of classification under the law must constitute a nexus relation between these two variables, that is the class itself and the law under which that classification is made, must have the relation nexus. That is the test of that particular reasonable classification. तो ऐसे क्लासिफिकेशन से हम इक्वालिटी को डिस्ट्रॉय नहीं करते हैं, रादर वी आर स्ट्रेंथनिंग दैट रूल ऑफ इक्वालिटी, बिकॉज वी हैव टू अंडरस्टैंड दैट all persons, all individuals, they cannot be equal in all the circumstances. So according to the situations, according to the circumstances, we have to give the treatment of law to such individuals in a different manner. That is something which is known as a reasonable classification. Now, when we understand this concept of reasonable classification, you could see that there are case laws which was decided by the Supreme Court. P.V. Narasimha Raw's Jharkhand Mukti Morcha case, Jayalalitha versus State of Tamil Nadu, Kathi Rani Rawat versus Union of India. ये कुछ लैंडमार्क जजमेंट है जिसमें somewhat different treatment is given on the basis of a reasonable classification, and it was challenged on the ground of violation of Article 14 of the Constitution. But in all these judgments, we understand that court rightly said that there is no any violation of equality, rather there is a reasonable classification, and the treatment of law is meted according to the circumstances of that particular transactions. And so, in brief, these are the things you need to understand when on a basic level, primary level, you are starting or you are studying this right to equality under the Indian Constitution. So thank you very much for watching my video. Keep watching, do like, share and subscribe to my channel. Thank you.